All right, hi, welcome back. Attorney Steve Vondran. Hope you had an exciting Super Bowl yesterday. I'll tell you what, the Chiefs were tough. Boy, what a game. So we are talking today about Respondeat superior. Okay, this is another one of those great Latin terms that you're going to learn in law school. This one is very, very important out in the real world. This is how you can hold another person liable, vicariously liable for the acts of their employees. So without further ado, let's take a look at the Attorney Steve Litigation Whiteboard. Okay, so here we have it. Here's your company. Here's your officers and directors. Down here, let's say we have, I call them a tortfeasor. This person on your bar exam is going to do something wrong. It could be an intentional tort. It could be an assault, a battery, a false imprisonment. It could be any of those kinds of things. It could be a crime, a burglary, a murder. It could be anything like that. It could be negligence. It could be dropping a bag on somebody or hitting them in the car on the way to and from work. So this is a very important thing, especially on your bar exams and especially out there in the civil litigator's toolbox, something you're going to want to be aware of. Now, let's take a look here. First of all, what does it mean? Anybody? Respondeat superior, what does it mean? If you guessed, let the master answer, you've got it. Let the master answer. The law has decided that, when the companies are out here making their money and they've got things that are out here, they've got a staff, it could be employees, it could be agents, it could be independent contractors, it could be temporary employees, those kinds of things. But when they're out there benefiting the workforce, benefiting the employer, benefiting the officers and directors, then you can have liability when it's in the course and scope. Okay, this is your magic words right here. This is what you're going to be looking for in every case. Within the course and scope. Now that's construed fairly broadly to bring a lot of different acts that this person did and hold them liable for it. Okay, so now the big question always becomes, well, if they were out driving their car going home, was that within the course and scope of the employment? Now, you've got to check your state law in your case. Every state's going to be different. I'm going basically off my understanding of California law, okay, but every state's going to be different. But course and scope of employment, you're going to look up the cases. If the person, the coming and going rule, sometimes they'll say, well, they were going to pick up lunch to bring it back to the company. Coming and going, and then an accident occurred. Okay, well, that may be in the course and scope of employment. Okay, you may have somebody with working out of a satellite office, and they're coming and going to their satellite office or a home office. A lot of people are using home offices for business. If you can make an argument that they're doing something in that home office that's benefiting the employer, like recruiting agents or doing deals, those kinds of things, that could also be seen as within the course and scope of employment. So if you can find that, you've got the parties will be joint and severally liable, meaning this person is always liable on their own for their own torts. Okay, they're liable, but they may not have any money or they may have very little money. Here's your deep pockets. Let's draw your deep pockets here. Corporation, deep pockets, okay? So sometimes you need to look to find that liability to bring in this company and or its officers and directors, like a copyright infringement case. Officers and directors can be held personally liable, okay, despite your corporate veil. So here's your tortfeasor. You're always looking for that. You're always looking to say, is this within the course and scope? Were they somehow benefiting the company? Was this in a foreseeable manner? Is this something foreseeable to the company where they would realize somebody's out working in a home office doing things and then doing maybe things they're not supposed to be doing in between? Those kinds of things. Any acts that are arising out of the employment relationship is another phrase you sometimes see, arising out of the employment, the foreseeable risks of the business, those kinds of things. And again, the policy here is out of all the parties here and here, the company is in the best position to protect itself by getting insurance. They're the ones that are getting the bigger gains and the bigger results out of the employment situation, so they should be held to bear more responsibility. Okay, so it's really a policy issue. Now, again, there's the coming and going rule. There's deviations. What if somebody is coming and driving to work, so they're on the way to benefit the employer, and then they pull off at a gas station and decide to beat somebody up. Is the employer going to be liable? Those can be questions of fact. Question of fact meaning a case that could go to the jury. Okay, so it's very important that you closely analyze the facts, especially now with this new AB 218 in California, where you can go back and hold the clergy members liable, or the camp master liable, or the old coach liable, and their institution. But it's the same analysis. You want to see some kind of benefit running to the employer, as this was in the course in scope. So this is a very, very important legal principle. I'm going to give you one other thing to think about. It's similar, but it's a little bit different. It's called negligent hiring. Okay, so even if you can't show it was in the course and the scope of employment, you may be able to show as a plaintiff over here that this company negligently hired or retained or failed to supervise the employee. This happens in real estate all the time. A broker has a duty to oversee and supervise the acts of its agents, okay? So here you can have something where you can, if you're not doing good background checks, or you know somebody's got a criminal past and you're putting them out there with people that maybe you shouldn't be putting them out there with, these are the types of facts that you're looking at to see if you can either get to respondeat superior, which is a form of vicarious liability, or if you have something more like a negligent hiring, negligent supervision, or if you have acts where the corporate officers are ratifying, authorizing, directing these kinds of actions, they can be held liable for these torts, even though it's a criminal tort, even if it's intentional, even if it's punitive and malicious in nature. So this is a very important tool in any civil litigator's toolbox. I want you to store that away. Definitely bar testable, going to be up on the bar, something like that. Who should be liable? Discuss. So be ready for that one. But there it is, respondeat superior. Let the master answer. Let the master answer, okay? Attorney Steve, I got to run. I've got some great videos coming up this week. If you like this video, give me that thumb. God, give me the golden thumb. And if not, and also make sure to subscribe. But we got some great videos coming this week, so make sure you're in there with us, okay? I got to run.